Hi guys, welcome back to season 3 of Just Legal. Very excited to have you guys. It's amazing just to think of the fact that we are now in our 3rd season. Makanda,
Yes.
Karibu sana.
Asante.
I want us to have a very interesting conversation. Now with Just Legal, we've been having conversations around law and very empowering conversations with our viewers. With the 1st and 2nd season, we really had a conversation talking about setting up structures for SMEs. We talked about divorce, and it had good traction, very many questions. And many guys kept asking us about property.
Yes.
So I thought, why not come and talk about estate planning and succession? So that's why you're here.
Obviously, we all know about estate planning in terms of planning, real estate. It's not real estate. It's transgenerational, which most people call succession, but succession is a bit limiting because that will generally deal with things like wills. But when you talk about transgenerational estate planning, it goes a little more beyond just doing wills. It includes things like family trusts, which then can morph into what people call family offices, which is basically a family trust or a family estate, which now trades almost like a company or a corporate. And you'll see most of these families, famous families that you know of, people who say, men who build America or something like that, set up family trusts for long, and now they are almost like corporates into themselves. And also, family trusts are more perpetual than would be generally a will. A will is more of sharing. Family trust is more into generating that wealth over a long period of time.
When you say perpetual, what do you mean?
Perpetual means for many years, forever.
Oh, forever.
Yes.
Okay.
Yes.
Now, succession and estate planning, I feel like has been like a buzzword right now. Why do you think at this particular time it has become so popular and there's this big need for that conversation to happen?
The thing about arranging your affairs, especially around assets, is because if you have no asset, there's nothing to arrange. And whatever people think about it, there's a growing sophisticated middle class that obviously is making a lot of moves and now starting to own stuff. And things have changed because 5, 10, 20 years ago, women in Kenya were not owning a lot. Now we have women who are having their own, assets and want to plan their lives. People have always thought that sometimes if you're couples, you need to put your things together. You don't necessarily need to. There are those, remember 20 or so years ago, or I think when I started my employment, you had
20 years ago.
15 or so, 20 years ago,
Makanda.
you had to declare your KRA, payee, together with your husbands. So the world has moved quite a bit. Sophistication, growing middle class, but also the reality of what people see on TV or the news every day about all these successful families in Kenya that are fighting each other upon every single death of especially the patriarch in Kenya. I can almost predict what's going to happen with military precision. So people are now starting to get scared that it's possible to have assets, which then will end up being wasted as the people who did not make them are eating them away.
In a nutshell, the most important reason as to why we are here is we recognize that our viewers, people have property, they have their assets, and it's very important that we are able to plan our assets. Now, does that mean if I have like my shamba, just that shamba in Kamulu, if I have like my car, is my car an asset?
Money market.
Oh, really?
Treasury bills.
So like what are like the assets?
So there are different asset classes. There are asset classes that require you naturally to appoint a next of kin. Things like life insurance policies, where if you pass on, they automatically pass to the person that you've nominated. If you set up like a trust, it's still possible to nominate that trust as the next of kin, in terms of those kind of asset classes. But we have the more loose asset classes, which is the biggest, of course, in Kenya. We are obsessed with is land and housing. And then, of course, we have cars and motor vehicle. Basically, You know, there's jewelry. There are certain communities in Kenya that are very particular about jewelry more than land.
Oh, really?
Yes, and they keep most of their asset value in gold, some sort of gold, jewelry, and necklaces and all that, and watches for people who love watches like me.
Oh, yeah.
Paintings, of course, people who love art. And then we have other things like money market funds, treasury bills, and all that. Basically, everything you consider valuable for you. It could be a nice Prada handbag.
Oh, really?
Yeah, because you know, there's one talking to a client who said, I want this Prada handbag to go to my niece. You know, yeah, because it's very particular to me, so stuff like that.
That feels like a conversation we really need to get into. Before we get there, let's recap. With estate planning, we have wills.
Yes.
You've mentioned we have trust.
Family trusts. So the most crude one is obviously, you know, dying, you know, or not doing anything about it.
Oh, okay.
So where you have your assets in your own names and in your own companies, and then when you pass on, those assets are then distributed. The court determines how they're distributed, which is intestacy. Intestacy is basically dying without a will.
Okay.
And then so the law has set out how those assets should be ideally distributed. And then we have what we call testacy, which is having a will in place. And there are modalities of how a will, you know, generally would look like. And who you provide for, and what the court can do to interfere with those kind of things. Finally is what we normally think the most sophisticated fashion is family trusts. It's very malleable in terms of how you structure it, but then it's not subject to, you know, it's very hard to go and break a trust in court for anybody who's aggrieved. Wills can be nullified by court. So your wishes can be nullified by court, but family trusts are very hard unless you can show things like fraud and all that. But I'm sure we'll get into detail about it.
Okay. I want us to break like some myths around wills. Yeah. You know, I'm thinking of it even with my own folks. Just that word, wills. Yes. People are very worried. Why do you think that is? Like, from our communities, why do you think that aspect of having wills, and just wills are just such heavy words to have around?
Of course, obviously, you know, it's a mix of culture and religion. Most of us, there's this joke that everyone wants to go to heaven, but no one wants to die. So it's more of that. People are just afraid of having, determining their own lifetime. And most of us, you know, hope that when death happens, it will happen when it's inevitable. The challenge has always been about planning around death, but it's not planning for death. It's planning around death. People need to understand. Planning
around death.
I
like that.
Not planning for death. The things that we see happening after people have passed on, sometimes, you know, it's possible for the children not to go to school because they are minors, and your siblings decide that they're the ones who are going to be administrators. And then they just live quite the life. And there are things, you know, for us lawyers, we see every single day, and we have no way to intervene because once your next of kin comes and says, I'm not going to court to be an administrator, we cannot say no. So the court rules, if it's your person, maybe you're a single mother and you have a sister or a brother, that generally looks like the next of kin. And sometimes they can be reckless with your assets, and your kids end up on the streets.
Now, what exactly goes into the will? Like, can I ask to be buried or for my body to be disposed in a certain type of way?
Yes, you can. Listen, wills are more about assets. Your body is not an asset in terms of being disposed. But yes, you can state some of your wishes, like you know, you want to be cremated and all that. But listen, that's still, by and large, depends on whether the people who are administering it want to observe that, because there have been fights about I want to be cremated, and then, you know, from where I come from in my village, it's not going to happen. In terms of disposition of your own personal remains, they can choose. People can choose to honor it, and sometimes the court can stand with them if they choose to dishonor it.
So what I'm getting is, with wills, they are subject to a lot of challenges. Like, you can challenge the will.
Yeah, most of the fights you're having, especially from these what I would call big families, most of them have had wills. You know, wills is about providing for what we call dependents, and dependents are people who will generally have depended upon you when you were alive. The natural distribution, of course, is if there's a surviving spouse, your children, then of course other people do come in, and this is where for us men it becomes a bit dicey. Consorts, sometimes do pop up and claim that this guy is used to pay my rent, and children that the family didn't know about, and then you have to go to the dishonor of saying we want to exhume the body and do the DNA. You've seen people fighting on where to bury. All that is basically around fighting for assets. There's no one who really cares about that somebody says, I want them to be buried in my plot. The other one says, I want to be buried in my plot. Those two ladies are not fighting for that dead body. It's more about people think that if I bury, then I have the right to the assets. So those are some of the challenges around wills. Wills, the courts have nullified wills, especially, for instance, if you have kids and for no good reason, the court determines that you refuse to provide for them out of spite. You have you say the children from this house, their mother is rude to me, so even if they're minor, I'll not pay their fees. This one is the one who used to own my bed in my old age. I want her to get all the money. The court will nullify that. So that's the problem with wills. They are respected, but as long as they make sense. If they don't make sense, the court will nullify them.
Makanda,
Yes.
I'm very curious. Like, I want to know what exactly constitutes a will. Like, what are the components of a will? Like, walk me through that.
Yeah, so we have two types of wills. We have an oral will, very hard to enforce. I mean, for people, even though we say Africans really never wanted to will away their to talk about death. Oftentimes when people got old, and I remember even for those of us who've grown up in the hinterlands.
Village.
Yeah, that's what you call it, the hinterland. So those of us who grew up there, you'll hear stories like, oh, mzee, 5, 6 months. Most of the time it used to be when they are very old or they are sick, quite sick. And they will call their children around and their spouses or spouse, and they will say, when I die, I have this plot of land, needs to go to this person, they should go to this person, they should go to this person. So there were beneficiaries were there and the witnesses were there. Sometimes they will call other mzes from the community. But now, because Kenyans have become excessively litigious.
What does that mean?
Basically, Kenyans do 3 things. They breathe. Okay, 4 things. They breathe, eat, fight online, and fight in court. Like, love moving in the court. So people do fight a lot. So the oral wills have started, dying away because most of the kids will come and say, that's not what he said, that's what he said. I'm the first one, I should get a bigger chunk. And all that, yes. Ideally, we have now written wills. Obviously, they need to be witnessed by at least 2 people. You need to provide for executors, who are the people who will distribute or administer the property.
The executor?
Yes, or executors.
That's the lawyers?
No. It can be lawyers. It can be your best friend, it can be your parent, it can be your children. It doesn't have to be lawyers. Lawyers will pretty much draft the will and prepare the will.
Oh, okay.
Yes, there are people who nominate lawyers as executors. To each their own. I don't advise people to appoint the person drafting to be again the person executing the will. So you'd rather have the lawyer just providing the legal support to the family. But appoint, professional executors who are like accountants and all that. Even lawyers, but not the one necessarily making the will. Secondly, we have what we call the beneficiaries. So beneficiaries, you'll say, for instance, this piece of land, I want this to go to this person, and this piece of land, I want to go to this person, and this, my jewelry, I want to go to this person. So you set out how each one is going to get from the assets. This one I want to go to charity, this one I want to go to church, this one I want to go to the mosque and all that. It has to be witnessed. It has to be signed. So it has the executor, it has the asset classes, it has the beneficiaries, and then it has witnesses. Every time you have a new asset, you can do an addendum, you can add or amend the will.
Oh, so I don't have to like redo it all over again?
Yes, you can add, yeah. Or you can change your mind and say, this will supersedes the previous one, and this new will, I no longer like Makanda. So, I mean, you don't say that, but you say, yeah, this, I was giving him the house in Runda, now he'll get the one in Koyonza. Wills, you must, it's good, if you don't provide for dependents, you need to know that the court, if any of those dependents can go to court and challenge it, and it will be nullified or shift the assets aside a bit.
Is it like public? Like, can I, I'm married and it's a secret. Like I just come to you as my lawyer and I'm like, this is what I want, this is it. But no one is aware. I even have a will, my spouse does not know.
Yes, because it's a private document. You can do it to the exclusion of anyone else. It's maybe just you and your lawyer. It's good to notify the executors you've nominated that this sort of will exists. But you do not have to notify the beneficiaries. You do not have to notify your spouse. You do not have to notify your family.
Okay.
Yeah.
So then why exactly do we have wills being challenged?
Yeah, so it's a challenge because one, I've said if you don't provide for all beneficiaries. Happens again a lot with men. They have a family, and they have an unofficial sort of family or children, and they make a will and exclude, and most of the unofficial children are actually minors. So obviously it means that the children will not be able to go to school and all that. So that child can go to court and have the will nullified if the will is not witnessed, if the will does not have executors, if the will wills other people's assets. You understand?
What do you mean?
So what happens is this. It happens to ladies and to do a will, but there's a property that my husband owns, but I contributed to it. So you're assuming it's yours, but it's not yours. You cannot put that in a will. You only put what actually belongs to you.
What about property we own? 50-50, like not even just my spouse, but my business partner.
Yeah, so there are two types of ownership. There's what you call joint ownership, which means that if you pass on, the property passes to the person that remains, and ownership in common, which means that it's an undivided share. So your share goes to your estate. But if what you actually mean is in common, then the title has to be indicated that it's been bought in common.
Makanda, let me ask. I go for sherehe, I'm in good spirits, I write down what I want, and I have at that time, I have 8 apartments, and out of those 8, you know me, my mom is my everything.
Yeah.
So in those 8, I give her 6. Then those other 2, the rest, others.
Yeah, so I mean, there's nothing wrong with willing away all your assets to one person. But the reality is that anybody that feels aggrieved can come and challenge it. And if they see that the decision was made irrationally, and you did not provide for dependents, it can be nullified, especially children, not spouses, especially children. Yeah, so spouses can challenge the will successfully or fail, but children, if they show that when she willed away her assets, she was irrational. Irrational doesn't mean crazy, just means that you are acting out of some sort of animus. You are making an angry decision. So the person that is listening to the matter, especially in court, will look at the totality of the evidence. But also there are things that note. For instance, you cannot benefit from your crime. So if you kill your parents, and you cannot, even if you're on the will, you cannot be.
Oh really?
Yeah, you can't. So those people planning to kill their parents, make sure if you get arrested
for the property,
you cannot. Yes, you cannot.
Oh my goodness.
And then we have if you make a will when you are drunk, that's lack of mental capacity. Either you have a mental health issue that is medically can be proven, or you are too inebriated. That will can be challenged. When you are too sick, like 2-3 days before you pass on, it's assumed you didn't have the capacity mentally to make those kind of decisions. So that can be challenged too.
So writing a will is not as easy as me just going and drafting. You actually need legal advisory.
Yeah, that's where we come in as MNO advocates. You go write down your wishes. We convert that into a will. So wishes become wills. And then we also honestly advise you, because you also don't want your will to be challenged. So one of the things we do is we advise you on how to write it, so that it doesn't then get challenged for not providing for other people, not being properly signed. So ideally, you come to us and we will give you that kind of advice.
And do I have to have like an amount of assets, a specific amount of assets, or a particular amount? Like, can I just have my shamba in Kamulu?
You can that shamba in Kamulu and Joska.
You're seeing us from the mountain. Obsessed with Kamulu Joska.
Kamulu Joska, yes. There are other places, but yeah, Kamulu Joska.
We just know Kamulu Joska, guys.
Yeah, so that Kamulu Joska plot, you can start from there. The bit about it is you can keep on adding. It's not a wealthy people's problem.
Yeah.
You just anybody who has an asset. It's good to start early and have that discipline, because it's you that has struggled for that asset, and you really want to have a say on how it's utilized posthumously.
There are all these things we don't know our lawyers would do for us. And what I've loved, at MNO we keep saying the difference is a great relationship, and we are going to work with you the long haul. I like the fact that I can just start with that property in Kamulu, and we can go adding addendums. We can go adding that property, and you're able to advise us so that you don't do your will and then at the end of the day it's challenged.
The alternative is a bit more scary, which is dying intestate, and so most of us assume we'll die old. It's possible to die at midlife, 40, 50, 60 years, and have young children. The proposition that your children might be in the streets, it feels like a very reckless decision to make.
Now, what happens when I die without a will?
Now, free for all, basically. So, free for all basically means that your next of kin or people who feel responsible enough for your well-being or well-being of your beneficiaries will go to court. If they are children, they could go to court if they're already adults. If they are minors, maybe your spouse, your siblings, your family, friends, and those are administrators. Now, those administrators, when they go to court, they are telling the court that, listen, this, I want to be administered the assets of the deceased person, and this is how I propose this is how I propose the assets to be shared. The court then distributes if there's no opposition. But if you have a lot of assets, people will or even not, people will come to court sometimes to object and say, I was also a child, or I was a dependent. So dependence does not necessarily mean a child. People just need to show dependency. So, for instance, if you have your sister's daughter that you are paying for school fees in Karima Girls, in the slopes of Abadeas, she can come to court and say,
really?
My aunt has been taking care of me since I was a child, and I owe to your beneficiary, even if you didn't have that plan. The challenge then becomes that the administrators can misuse the assets, because they are not people that you wanted to take them to. You didn't trust them. I mean, if you don't trust, let's say, your father or your mother or your brother or your sister or something, you don't want them to be the ones administering your assets.
Does your spouse have to also prove they are your spouse? Because imagine there are 3 other women saying you are supporting them.
The problem with the succession, especially for intestate succession, is that the courts have made a decision that even ex-wives and concubines can inherit. So they just need to show that they were those. You don't have to be officially married.
If you die without a will or any plan, is there a space where you, your family can salvage that and get lawyers?
No, court.
Oh, really?
Once you die, in fact, you are not allowed to deal with the estate of somebody who's passed on without a court order. That's called intermeddling. It's a criminal offense.
How long does it take?
A succession process which is not contested takes about 8 to 12 months. And the minimum 8, maximum about 12 to 16 months, depending on the court diaries. The ones contested can take. Their cases have been running from 1982 to now.
Oh, really? And now, by the way, in that period of time when it's a court thingy going on, do we still use the land? Like if we are living there, do we still live there? Do we still farm the land? Do we still like collect rent?
I mean, the work of the administrator is to ensure that the estate doesn't go to waste. So you get temporary letters of administration, which is, of course, if there's an apartment, you collect rent, but the money is not distributed. If you need to make any distribution before the matter is concluded, for instance, the medical bills, school fees for children, upkeep for the family, you make an application to court, and the court will give you a provision to take out some of the money to pay school fees and all that. And also in the distribution, at the end now, of course, there's a distribution matrix. You know, you pay the taxes first, you pay the legal cost and cost of any accountants that are there. Of course, there's a payment for cost of burials and cost of medical bills for the deceased person, and then now this cost of upkeep for the family, and then what remains, the residual estate, is what is distributed to the beneficiaries.
That's really scary and sounds very, like us guys on Twitter would say, chaotic. So what would you advise?
It depends with how much you care about the people that survive you. Yeah, not about yourself. Some people, of course, like that thrill of what wajipange. There's nothing wrong with that. But if you really care about people that will survive you, and mostly your children, I wouldn't advise you to wait, because people also say, I'll wait to make my will when I'm 60. Please start considering that. Put together your affairs. Talk to us as at MNO Advocates. We start, you know, the low-hanging fruit is always a will. Even as we graduate to what you will call a family trust, which is now more sophisticated, more robust, but needs a lot more attention.
We've talked about now what happens when you die without the will, the process, and it's chaotic, and you advise, like, let's start with the wills. So what's the process of actually like administering through the court process, the will?
It's a petition, a whole petition, but a will is part of the petition documents. And the court, of course, then appoints executors, and then, you know, a temporary grant is granted, and then is confirmed. After confirmation, the distribution happens in accordance with the will, or how the court has readjusted if there's been an application for readjustment. What
happens to like kids who are going to school?
Again, same thing, provision. The court can make temporary provision for kids who are going to school. When
you're putting the property in the will, and I want my title to go to daughter A, let's call her Liz. Hi, Liz.
Yes.
Now, with Liz, can you change the title in the will, like, or it's going to be under my name?
The title remains in the name of the person that is doing the will until after death. If you transfer to the person, it's not a will. You've given out already.
Because that's already
gone. It's already out, yes.
Okay, even
but
if they didn't...
that is actually a way, by the way. Thanks for that. It's a way of distributing your assets. You know, you can distribute when you're alive. Yeah, nothing stops you.
Is that under succession?
To be honest, it's a way of transgenerational estate planning. But Liz, all this we've been talking about, you've noticed it's distribution.
Yes.
I feel that wills are good, temporary measure, but the more people get deeper into this, you transition to family trusts. For instance, if you have a company, you don't want it to be shared. You want it to continue operating, because people are also keen about legacy. You own this successful school, again, the slopes of Abadeas. You want, when you're not there, it can only change the name to Elizabeth Memorial, but you want the school to continue being there. But you know your kids very well. You know that the day they are just chilling, waiting for you to go and distribute. Now, that's when you morph into something like what we call family trust. Family trusts, the kids, you determine what happens to your asset 100 years from today or 20 years from today. So that's a whole world now where, for people who run, first of all, own family businesses, have assets that are generating a lot of income. You want people to get the benefit out of the assets rather than own the assets per se.
Okay, yes. That is an interesting conversation. I think you need to come back for that. Yes. Which is anyway why we are working hard to build that empire or create wealth, really, and you don't want it to just end with you.
Yeah, I'm happy.
Awesome.
If you invite me to come back again, because at MNO, relationship is key for us, and we want to help our clients walk from the dark alleys of intestacy
Dying without wheels, guys.
Dying without wheels. And then as they grow into sophistication, help them set up family trusts. Yeah.
Ladies and gentlemen, you had it here first. I think we've had such a robust conversation, and I'm sure there's so much more that we can discuss about, you know, family trust. I know you're going to have a lot of questions. Please do not forget to tell a friend about our podcast. Share this conversation. It's important that we grow together, we learn together. Comment your questions. Let us know any questions you'd have. I know Okalle will be here.
Yeah.
Right?
Yeah, we have a large team, so we can't get overwhelmed. We are a team of about 12 lawyers, 12 advocates, and all of us are quite competent at what we do. So all questions will be responded to, and obviously the people, our numbers are public. Yes.
So keep it here. Check out our pages. Our socials will be in the dialogue box. So yeah, keep it just legal.